Hey, I wanted to take a quick second and discuss a problem that we're seeing several clients encounter right now who have homes owned in what we call a Medicaid Asset Protection Trust, which is a specific type of irrevocable trust that is intended to protect its assets from a spend down if there's a need for a long term care and the desire to become eligible for Medicaid. Now, the problem we're seeing is that right now, because interest rates are so low, many clients are wanting to refinance their home, and sometimes the homes that are owned in these trusts are still mortgaged, and clients want to get a better interest rate on that. Totally understandable. But we're seeing a string of people make a perfectly reasonable and intuitive mistake, but a mistake nonetheless. So, what I want to address very quickly is what not to do if you have a home owned in this type of trust, an irrevocable trust, especially for Medicaid qualification purposes, so that you can still get a better interest rate on the mortgage, but not mess up some of the planning that you've done so far. So, the problem is that once you put a house or any asset into this kind of trust, you essentially start the clock on what we call a look-back period. 60 months or 5 years where that gift that you made to this trust is still penalizable by the state in the future if you want to qualify for Medicaid. Now, once you get past 5 years or 60 months after you've made that gift, then you're out of the woods as far as the penalty period is concerned. But it's important during that 5 years that you don't do something to sort of mess that up, or you're going to have to essentially restart the clock. If you make a certain kind of mistake, then a new 60 months or a new 5-year period starts, and that's what we want to avoid if we can. So if you're trying to refinance a house that's owned in a Medicaid Asset Protection Trust, what you don't want to do is deed that house out of the trust back to yourself, qualify for the refi, and then deed the house back to the trust. Sometimes that's what even the bank or the mortgage company will tell you to do. It's going to take a long time to qualify you if the house is still in the trust, so it's going to be easier and quicker if you'll just deed it back to yourself. Will qualify you for the refi, and then you deed it back to your trust. That's a normal and an acceptable thing to do if you've got a revocable living trust, very common. But if you've got this kind of irrevocable trust that you're using to get outside of that look-back period, that's a bad idea. Because once you get the house out of the trust back into your name and then deed it back to the trust later on, now we've got a new 60 months or 5-year period that we're trying to get through. The better idea is to keep the house in the trust and just tell the bank, listen, I'm okay with having to go through a little bit more of a lengthy process in order to get a better rate, but I don't want to mess up my look-back period, so I'm not going to take the house out of the trust. What you want to make sure you look for inside of your trust, because the bank's going to be looking for this, is number one, does your trust allow you or someone else to substitute assets of equivalent value? That's an important provision even if you're keeping your house in the trust. And then, does it allow your trustee to apply for and qualify for, on your behalf, these kinds of loans? So those are important provisions. You can look for those provisions yourself. You can have your attorney or us review your trust to see if those provisions exist, but they're going to be key in allowing for the refinance process to proceed. Now, what do you do if your trust doesn't have those provisions? If you've got an irrevocable trust that says nothing about lending or substitution of assets, you can hopefully, if your trust was drafted with a trust protector or trust advisor, they have the authority to amend the trust and add those kind of provisions. Or all of the interested parties, meaning you, the person who created the trust, and maybe your living children or your trustee or whoever the beneficiaries of the trust are, can all agree under Oklahoma law. They can consent to modify or amend the terms of the trust somehow. So trust protector is option number one if they exist. If not, then a consent of all the parties is an option as well. But what not to do, again, is take the house out of trust, deed it back to yourself to qualify for the mortgage or the refinance, and then put the house back in trust. That is inevitably going to restart the clock on the look back period, and that's exactly why you created this trust to begin with, was to get out ahead of that. So we don't want to have to start back from scratch just because you wanted to get a better interest rate on that home. If you're needing some help on this, or you've got some questions about whether or not your trust has these provisions or what you should do if you're trying to refi, give us a call, 918-770-8940, or visit us at tallgrassestateplanning.com. Reach out to us, and we will do our best to help you out with this.